Students with disabilities have the right to an education that allows them to meet their full potential and contribute to society. We rely on education providers to ensure that every student has the skills and knowledge they need to succeed. Good morning, everyone. My name is Raj Deer. I'm the Executive Director and Chief Legal Counsel of the Ontario Human Rights Commission, and I'm very pleased to welcome you this morning to what will be the second of 3 scheduled training sessions to the public. Now, as many of you know, the Ontario Human Rights Commission's policy on accessible education for students with disabilities was released in August 2018. The response that we've received has been overwhelmingly positive and has affirmed our view that there's a demand from the public for guidance and more information about these issues. What we're trying to do with these training sessions is ensure that you, the people on the front lines, are equipped to be able to support this demand. Many of you are here from school boards, colleges and universities, disability advocacy groups, your teachers, your guidance staff from disability and accessibility offices, and your parents. This is your reality, and in many ways, the fact that we are all here together provides us with an opportunity to learn from you as much as you can hear from us. I'd like to now turn to introducing you to the Commission's lead on accessible education for students with disabilities, Sherry Robertson. Sherry has worked as a senior policy analyst at the Commission for 15 years. She develops and drafts public policy on a range of human rights and social justice issues. She delivers public education, undertakes consultations with stakeholder groups and the broader public, and is a regular presenter at seminars and conferences on human rights and equality matters. She's the author of numerous OHRC publications, including, of course, the policy on accessible education for students with disabilities. So I'd like to welcome Sherry. Thank you.
Thank you, Raj. Good morning, everybody. So we are live streaming this. So we still, though, won't change the format. There will be plenty of time for you to ask questions throughout, and there will be a formal Q&A at the end. I've created 2 scenarios for discussion purposes, which are in the materials that you have in front of you. And the format of my presentation will be that I will give you an overview of the contents of the policy. As many of you will know if you've accessed the policy online, it's long, it's detailed, and there will be sections that you may need to look at more closely for areas that affect you specifically in the day-to-day work that you do. But today, I will be giving you at least a sense of what is in that policy and where you might be able to go for further information. Okay, so many of you will know that the Commission has been doing work in this area for a number of years. I personally have been doing work in this area back to about 2002. We did a province-wide consultation in 2003, which revealed a lot of significant barriers facing students with disabilities throughout the education system, all the way from the primary levels up to post-secondary. In 2004, we put out the guidelines on accessible education. The policy that we'll be speaking about today is an update of this earlier policy. But in that intervening period, we were busy doing other work, looking at issues that arise within disability and education. So in 2005, the Commission initiated complaints, human rights complaints, against both the Toronto District School Board and the Ministry of Education. And that related to the effects of the Safe Schools provisions of the Education Act on racialized students and students with disabilities. We were able to achieve settlements in both of those cases, but the barriers that gave rise to those complaints have not gone away. They, in some cases, have taken different forms, but yet remain. So we know at the Commission there's still work to be done. In 2012, the Commission intervened at the Supreme Court of Canada in the Moore decision, which dealt with a student who had dyslexia not receiving appropriate accommodations in BC. In 2015, many of you will know that we intervened in a complaint against York University that dealt with the kind of information that students with mental health disabilities have to provide to post-secondary institutions to get accommodations. And in 2017, we published With Learning in Mind, which looks at specific barriers for students with mental health disabilities at colleges and universities. So despite some of the gains that have been made by people with disabilities, so for instance, since we started this work, we've seen some significant case law which has helped to advance the rights of people with disabilities. We now also have the Accessibility for Ontarians with Disabilities Act, and at the international level we have the Convention on the Rights for Persons with Disabilities. So there has been some progress, arguably, but Statistics Canada reports that Ontarians with disabilities continue to have lower educational achievement levels, a higher unemployment rate, and are more likely to have low income than people without disabilities. And it's clear that students with disabilities continue to experience these barriers throughout education. Some of the more common barriers that we heard about in the consultation that we did in the update of this policy were things like inadequate resources and supports in the classroom or learning environment, long waiting lists for assessments, negative attitudes and stereotypes, physical inaccessibility, inappropriate requests for medical information, ineffective dispute resolution processes, and outright denial of disability-related accommodations. So the Policy on Accessible Education for Students with Disabilities 2018 takes into account current social science research, including critical disability studies. Since we did the work back in 2004, it reflects current human rights case law that deals with disability and education issues. It takes into account new legislation, and it looks at the developments at the international level. The Commission develops policies. It's part of our mandate. The Commission's policies are a little bit different than the policies developed by other organizations in that there is a provision in the Ontario Human Rights Code that states that if a party has filed a human rights claim with the Human Rights Tribunal of Ontario, they can ask the tribunal to consider a Commission policy that is relevant to their case, and the tribunal is obliged to do that. So there is some legal heft to the Commission's policies. They are our best advice to organizations on how to make sure that they comply with their responsibilities under the Ontario Human Rights Code. And our Commission policies underlie all of the other work the Commission does under its mandate. So any communications to the public or the media will be informed by our policies. They can be the basis upon which we will conduct public interest inquiries into areas where we think that there is tension and conflict that requires our attention, and they inform litigation strategies in the work that we do in a more formal legal sense. Yes, there's a question?
As the tribunal is obliged then to consider these policies, or this policy and the matters therein, then are you going to be training the people who are chairing the tribunals on what is expected regarding each of the areas mentioned within this policy in order that they can adequately understand what they are to do? I mean, we hear a lot of complaints from families about the fact that the tribunal is not impartial, not fair, and doesn't know enough about education in order to adequately assess and evaluate in order to make an appropriate decision.
That's a really good point. We have a training session in the next 2 weeks with the Human Rights Legal Support Center, which is part of the human rights system, and they are the lawyers that argue in front of the tribunal. But you raise an important point. There's also an opportunity for us to train the vice chairs at the tribunal, and I'll bring that back, and we can explore the possibility of that. Thank you. So I'll say a word about terminology. You'll see throughout the policy the phrase education providers. Education providers include, but are not limited to, school boards, school staff, educators themselves, and at the post-secondary level, colleges and universities, instructors, teaching assistants, administrative staff, staff and offices for students with disabilities, and where appropriate, it may also include government, including the Ministry of Education and the Ministry of Training, Colleges and Universities. Other related service providers that are captured by the code would be daycare providers and after-school programs. The policy focuses on ableism as a belief system that often underlies negative attitudes and stereotypes that face students with disabilities. Ableism is analogous in many ways to racism and sexism. Ableist attitudes are often premised on the view that disability is an anomaly to normalcy rather than an inherent and expected variation in the human condition. And a great deal of discrimination faced by students with disabilities is underpinned by social constructs of normality, which in turn tend to reinforce obstacles to integration rather than encourage ways to ensure full participation. And one of the examples that we were given by the Canadian Hearing Society is a university professor asking a deaf student to sit at the back of the lecture hall so that his interpreter didn't distract the other students. The student was told that he will not have interpreters in the real world, so why should he get to have one at university? So an example of how attitudes can often underlie behaviors. Yes?
Could you just repeat that phrase that you said, expected variant expression of, what was the phrase you used?
I said that oftentimes discrimination faced by students with disabilities is underpinned by social constructs of normality, which in turn tends to reinforce obstacles rather than to encourage integration. Is that what you meant?
No, you used a particular phrase that I wanted to capture that I really liked, as opposed to an expected variant of humanity.
Right, right.
Like what did you say?
That ableist attitudes are often premised on the view that disability is an anomaly to normalcy rather than an expected variant in the human condition.
Okay, expected variant, that's what I wanted to hear. Okay,
yeah.
Thank you.
You're welcome. The policy emphasizes intersectionality because, of course, we know that students with disabilities frequently identify by other grounds that are also protected by the Human Rights Code, and the interrelationship of these various aspects of people's identities can very much influence how they experience discrimination and harassment. We've taken that into account throughout the policy and given examples. So, for instance, a student with a disability might also identify by the ground of race or creed or sexual orientation, as well as many other possible grounds. And a couple of examples to illustrate the intersectionality that students may find in terms of how they experience discrimination. The Commission continues to be concerned about reports from the primary and secondary levels of education that relate to students being streamed into applied and special education programs based on stereotypical assumptions about their capabilities that relate to their identification with the grounds of both race and disability. So for instance, the Toronto District School Board reported in 2013 that students who identify as Black are the largest racial category represented in congregated special education schools and are notably underrepresented in gifted, international baccalaureate, advanced placement, and elite athlete programs. We've also heard from members of Indigenous communities that Indigenous students are similarly overrepresented in special education placements. An example of a post-secondary proactive effort to address these issues related to intersectionality would be a university organization providing support services to the LGBTQ+ community to ensure that its literature is available in alternative formats that are accessible also to students with visual and other types of disabilities. One of the areas that has evolved considerably since the Commission first started its work in this area is in the area of inclusive design and education, also known as universal design for learning. Universal design for learning emphasizes equal participation and recognizes that all students have varying abilities and needs. And this method of design is a preferred approach to removing barriers and to making one-off accommodations, which assumes that existing structures and approaches may only need slight modifications to make them acceptable. And UDL is more effective because it emphasizes accessibility and inclusion from the outset. It can be less resource taxing and time consuming than certain individual accommodations. And it also fosters student independence and autonomy, avoids stigmatizing individuals, and removes the burden on individual students from having to advocate on behalf of themselves. So we talk about some concrete ways that educators at all levels of the education system can incorporate universal design for learning throughout their programs, their policies, and their structures. Things, for example, like textbooks and course materials being available in electronic formats, a variety of assessment methods being available to students, lectures with closed captioning, lectures being recorded and made available in alternate formats. So, under the Human Rights Code, education providers have a duty to accommodate students with disabilities to the point of undue hardship, and I'll say a bit more about undue hardship in a bit. But the three principles that mark the accommodation process are respect for dignity, individualization, and integration and full participation. And we talk about each of these three principles at length in the policy. We also talk about the fact that the duty to accommodate has two different components, the procedural component and the substantive component. And the process that an education provider goes through to explore accommodation options is every bit as important as the actual accommodation or the substance of the accommodation that may be provided. So let's take a moment to look at scenario 1 in your handout to explore this theme a bit further. I'll read the scenario, but then I think what we can do is just take about 5 minutes for you to think about it on your own, and then we can discuss it as a group, and I'm happy to answer any questions. But the scenario is this. A university professor in a nursing program, and feel free to follow along, it's in your handout. A university professor in a nursing program requires all students to demonstrate proficiency in her course by passing an in-class essay test worth 100% of the student's final grade. The primary aim of the course is to teach students clinical evaluation methodology. Dina has a disability that makes it difficult to process large amounts of written material under strict time constraints. She asks whether there is any way that she can show her proficiency in another way, and she is told that there will be no exceptions to the requirement. So there are a series of questions. If you could just take some time to think about those. I'll break for about 5 minutes. Okay, so let's go through these questions together. And we have 2 mics on the floor, so if you would like to answer a question, just raise your hand and we'll get a mic to you so that everyone can hear you. Has the professor fulfilled her role in fulfilling the university's duty to accommodate? Do you want a mic? Okay, hold on, there's a mic coming.
No, she has not, or they have not.
Do you want to elaborate a little bit?
No, she has not. So she's not respected individuality or the student's dignity. There's been no process to identify what kind of learning style is best for the student. Individualized education plan. She doesn't know what her strengths are, what her challenges are. She might be an audio learner or visual learner. None of that's been identified.
I think extended time limits are a pretty easy accommodation, unless there was some point to be made about the speed of responding to a clinical situation. That might be an inherent requirement, in which case there's many alternative ways of communicating your knowledge other than in writing.
Okay, so I will say more about what we call bona fide academic requirements, the requirements that really arguably could not be waived because they would alter the essential nature of that particular credential or that skill set that's being tested, but that's a great something to put on hold. I'll speak about that in a few slides. But I think that the point that I'm trying to emphasize with this example is that regardless of whether the professor believes that the style in which she is evaluating students can be altered or not, there still is a legal responsibility to go through a process to see whether there are any alternatives, any other ways that this particular student might be able to show that she's mastered the curriculum content. So again, the two strands being the process and then the substance of the actual accommodation provided. You still have to go through the process, even if at the end of the day it's determined that there really isn't any accommodation that is available. I'm not saying that's the case here, but you need to go through that process, and if you are in the position where you're involved in going through those processes, I strongly recommend you document every step that you take. Okay, yeah?
I can't hear everyone, so I apologize for that. I hope I'm not repeating what's been said. But I think we also have to look at, has the professor been informed of her legal obligations and duties? And if she hasn't, she just may not know any better. So I would want to know if the university has provided training in that area to the staff, if there was something sent from their Human Rights Department to the professor regarding the types of strategies that could be provided, because the professors certainly are not well trained in the types of accommodations that are necessary. And I think too that one thing that's missing here is also the mention of the Accessibility for Ontarians with Disabilities Act. So it's all of those factors that come into play. It's not just the accommodations that the student requires and must receive under the law, but what the providers know about their legal obligations.
Yeah, so on that point, throughout the policy, we have made recommendations to all responsible parties throughout the education system, and one big area that we've emphasized is the need for training. I will say that at the college and university level, all institutions in Ontario have offices for students with disabilities that tend to act as a go-between between students and faculty. This is out of concern for respecting confidentiality and for a recognition that students oftentimes really benefit from having an advocate that knows the details of not just the Ontario Human Rights Code, but the AODA, any university college policies that are in place. But certainly it is to everybody's benefit if instructors themselves are familiar with these things. So I'll just point out that that is the framework within which we are dealing.
What you said earlier is that the information around accommodations would be circulated to the offices of disability. But since universal design is the first principle, what training is there throughout the education system at all levels around universal design? Because that's about preventing these kinds of things.
Yeah, so that is one of the key recommendations that we make at the post-secondary level, universities and colleges, as well as the Ministry of Training colleges and universities, to be much more proactive in the way that they train the staff who would be involved in implementing aspects of universal design, but also for those entities to take a leadership role in making sure that that happens throughout the education system, and the same is true for the primary and secondary levels. Okay, so I think that we've covered questions 2 and 3. So even if the professor believes that there is no other way that she can evaluate clinical evaluation methodology in another way apart from a 100% in-class essay test, whether that is true or not, there still needs to be that exploration of options, and then that will give more information to assess whether in fact there is an alternative that's available that wouldn't compromise academic integrity and would allow that student to demonstrate mastery of the course content in a different way. Some of the more common types of accommodations that are requested in education are things like modified buildings, facilities, and resources, alternate methods of assessment, which is what we've been talking about, flexible deadlines or extra time given, and in fact, the most commonly requested disability accommodation in education is extra time. And the Human Rights Tribunal of Ontario had occasion to comment on this in a case called Fisher and York University. It's a 2011 case. And the tribunal stated in this case, and I'm quoting, "The purpose of accommodation is to allow students with disabilities to demonstrate their ability to master the content and skills required to successfully pass the course without disadvantage because of their disability. Examination accommodations such as increased time allows students to do just that. The accommodation takes into consideration the impact of the disability on the student's ability to write tests and examinations." Other very frequently requested accommodations are academic materials in alternative formats, so in Braille, for example, large print, digitized text, voice-activated software, assisted hearing devices. Students also ask for alternate forms of communication, including sign language interpretation services, real-time captioning, and just in general, that policies and procedures be more flexible to meet the individual needs of students with disabilities. So things like making attendance requirements flexible where possible if non-attendance can be shown to be linked to a student's disability, time off or leaves of absence where required to attend treatment, for example. The policy has a specific section that outlines the roles and responsibilities of all of the parties to the accommodation process. So students, for example, or in the case of younger students, their parents, must make their needs known to the best of their abilities wherever possible. They need to participate in the accommodation process and answer relevant questions about their restrictions and their limitations. And I'll give you an example. In a situation where a college student requires an extension on an assignment deadline due to a setback related to a mental health crisis, the student would be required to communicate this need to the college and to provide medical documentation that verifies the existence of a disability. If ongoing accommodation is required, the student would be expected to communicate with the university, or the college, sorry, about her needs on an ongoing basis. So it's that it's the recognition that an education provider needs a certain amount of information to be able to facilitate the accommodation. In this section, there's also clear instruction to education providers on what they are expected to do throughout the accommodation process as part of the duty to accommodate. So for example, they should accept accommodation requests in good faith unless there are legitimate reasons to doubt that the request is authentic. The education provider is entitled to medical documentation to substantiate the student's needs, but it should not be used to second guess the information or treat the student with suspicion. I'll say a little bit more about medical information, but I'll just flag for now that in the vast majority of cases, a request for diagnostic information is not acceptable. The Commission's done a lot of work in this area. I'm sure many of you know that, particularly at the post-secondary level where this becomes more of an issue, arguably. But I'll just flag that for now. So I'll give you an example. A boy in grade 2 regularly interrupts his classmates and disrupts the teacher's lessons. When repeated reminders do not improve the problem, the teacher considers her options. Before escalating the situation, she contacts his parents to make further inquiries. Together, they arrange for an educational assessment which reveals that the boy has autism spectrum disorder. They are then able to take steps to put the appropriate supports in place to help him succeed at school. So this is an example of a teacher taking an active role in the accommodation process. Something that we have heard a lot about in the last few years from colleges and universities is an issue that has been referred to by colleges and universities as retroactive accommodation. So this means accommodations provided after a test has been written, after a deadline has passed, after even a course has been completed. When we first heard about this phrase, retroactive accommodation, we were a bit perplexed because from the Commission's perspective, accommodation is just accommodation, regardless of when it's happening. And we have taken the opportunity in this policy to clarify our position around this. Of accepting accommodation requests in good faith, education providers must meaningfully consider requests as they arise unless there are legitimate reasons for acting otherwise. So this would include situations where accommodation requests are made after a deadline has passed, an exam has been written, a course has been finished. Policies and practices that imply or state that education institutions will not consider requests for accommodation after the completion of a deadline test or course will raise human rights concerns. So depending on the nature of a disability, a student, or in the case of younger students, their parent or their guardian, may not be able to request accommodation in a timely manner. For example, some types of mental health disabilities may leave a student unable to identify that they have a disability or needs associated with that disability. A student may be experiencing a disruption in their functioning, but may not be able to attribute that to the presence of a disability. So as we know, many mental health issues emerge for the first time between the ages of 18 and 25, which is precisely when many students are at post-secondary school. So the policy position the Commission has taken is in recognition of that fact. And a student may not have prior warning that they will have accommodation needs, so they may not be able to proactively ask for an accommodation. So in these circumstances, if a student has failed to meet performance expectations, the institution has an obligation to consider accommodation after the fact. I'll give you an example. 3 weeks into the second semester, a disability office receives an accommodation request from a student who wants to write a final exam that she missed from the previous term. The student makes the request as soon as she is able, saying that she missed the exam because she was hospitalized suddenly for a disability. She provides medical documentation to this effect. The school makes the arrangement for her to write the exam and adjusts her final mark accordingly. So that is the Commission's position. At the same time, students should communicate their needs to their educational institution as soon as they are able, and should be prepared to provide documentation to support their request for accommodation. So while education providers have a responsibility to consider all requests in a meaningful way, the duty to accommodate is not limitless. There may be narrow circumstances where it might not be reasonable or it might not be possible to accommodate a student's disability, such as, for example, where too much time has passed, where the course is no longer being offered. We're talking about often, I've heard about requests being made years after the fact. So these cases are to be evaluated on an individual case-by-case basis, but I've set out for you what the Commission's position on this is. It is also the Commission's position that organizations covered by the Code, including education providers, are responsible for covering the cost of medical documentation that they require in order to facilitate an accommodation. And there will be cases sometimes where students have access to outside sources of funding. For example, at the post-secondary level, that might be a bursary for students with disabilities. Education providers themselves often have access to special government funding to offset the costs. It's expected that both students and the institution avail themselves of those outside sources of funding, especially before the institution tries to say they can't provide an accommodation because it's too costly. And we have had some case law on coverage of costs for accommodation, but when it comes to some of the bigger ticket items like professional assessments, we don't have that litigation yet. But it is the Commission's position that it is part of the procedural component of the duty to accommodate if an education institution is asking for this as a requirement in order to provide accommodation, that it would not be reasonable to ask the student or their family to pay for it. Once an appropriate accommodation is received, students must still be able to perform the essential requirements of the education service. So this is what I was talking about before in the nursing example. Oftentimes the pushback that we get from mainly post-secondary institutions around providing accommodations is that they are concerned that The accommodation will give an unfair advantage to a student with a disability, that providing the accommodation will compromise academic integrity. And this is particularly a concern, it seems, in the professional schools, like medical school, law schools. So we have made it clear that there is a process to evaluate whether a requirement is actually essential or not, and it's not acceptable for an education institution to prematurely jump to the conclusion that an accommodation can't be provided because, of course, writing an exam in 4 hours in an essay format is a legitimate requirement because that's the way we've always done things. That kind of rationale won't work. And I'll give you a couple of examples where these kinds of arguments have been struck down by the tribunal. But I guess what I'm trying to say is if this is something that you do deal with in your day-to-day work, the policy has set out a way of evaluating whether an accommodation actually would impair or compromise academic integrity.
I have a concern with the giving professional assessments, especially with the school boards who have their own school psychologists. Oftentimes I've seen psychological assessment does not, and the diagnosis does not match the recommendations. And it seems to be that the psychologist is not acting independently with the school board. And how do we, it's fine that if we say the school board has to pick up the tab for the assessment, but it's their person doing it, and their person's under a fair bit of pressure to do what the school board does. It's not an independent assessment.
That's a good point, and I think a similar issue arises in the employment context, which is when you get into second opinions and so forth. When we litigated against, we got involved in the intervention against York University in the Denota settlement, part of the work we did was to reach out to the Ontario Medical Association and the College of Physicians and Surgeons of Ontario to talk to them about what medical notes should include, because one of the biggest complaints we've heard is that they're too vague, and therefore more requests for information are required to get the substantive kind of information related to the needs and restrictions that education providers do need to facilitate an accommodation. So we are working at it on multiple levels, but I note the concern that you raise.
One problem that seems to constantly come up, and it relates to all of this, is psychologists, language pathologists have to be reminded that although they are employed by the school board, the client is the child. And under their own professional colleges, they have to work in the best interests of the client. And so really, they have to provide an assessment that's in the best interest of the child. They are not allowed to take any direction from the board that would be in contravention of that.
Right, and that would seem to go to the professionalism of the role that they're playing. Okay, I'm going to move on. We'll definitely have more time for questions. I just want to make sure we get through everything. Okay. So just finishing off on the bona fide academic requirements point. So we talked a little bit about, in the nursing example, about the fact that students with a disability may very well need to have an alternate way to show that they've mastered the curriculum. They still are required to show in some way that they have mastered the curriculum. And so I talked a little bit about some of the pushback that comes from the professional schools, and I'll give you an example. So this is from a case that arose in BC. The case is Kelly and the University of British Columbia, a 2012 case. And I'll just read the facts to you. A doctor enrolled in a residency program required accommodation of his ADHD and other disabilities to complete his rotations within various teaching hospitals and community practices. A human rights tribunal found that the university offering the program discriminated against him when it decided, based on a, quote, impressionistic conclusion that providing the accommodation would fundamentally alter the program or lower its professional standards. The tribunal found that there must be a substantive factual foundation to support a conclusion that a person cannot meet an essential requirement of a program. So in our consultation, students and their advocates very frequently told us that education providers can be too quick to jump to a conclusion that they can't provide an accommodation because of concerns like these. And I just raised this case as an example because this is a program where if the argument was going to be successful that the nature of the program itself required candidates to perform in certain conditions, this would be it, and it was struck down. So I think that's a note to colleges and universities in lower level programs that if this didn't work in a medical school environment, I don't think it's going to work for your average run-of-the-mill undergraduate accommodations. So I just raised that for your consideration. I'll talk a little bit now about the duty to inquire. In general, the duty to accommodate exists for needs that are known. Education providers are not usually required to accommodate needs that they're not aware of. However, in some circumstances, the nature of certain disabilities may leave students unable to identify that they have a disability or that they have accommodation needs. And as well, I should note that some students may still be very reluctant to disclose that they have disabilities. This point was raised a little bit earlier, particularly because some disabilities, for example, some mental health disabilities, continue to be highly stigmatized. So there may be that factor. A student may not have made a formal request because of fear of some kind of negative repercussion. So our position in the policy, and this is coming out of employment case law, so very clear legal duty coming out of the case law, is that education providers, if they are aware, or they reasonably ought to be aware, that there may be a relationship between a disability and a student's behavior or their academic performance, the education provider has a duty to inquire into that possible relationship before making a decision that would affect that student negatively. So a severe change in a student's behavior or academic performance could signal that the situation warrants further inquiry. And the policy states that before sanctioning a student for misconduct or unacceptable behavior, an education provider must first consider whether the actions of the student are caused by a disability, especially where the education provider is aware or perceives that the student has a disability. So an example, a student begins to behave oddly and out of character in class. His behavior includes unexplained crying, incoherent speech, and strange accusations directed toward students. Classmates and teachers become concerned about his well-being. The administration believes that he might have an undisclosed mental health disability that requires accommodation and approaches him to talk about his behavior and to offer assistance. It should always be kept in mind, and this is stated in the policy, that inquiries about possible disability-related needs have to be handled with sensitivity. So there's a line for sure between inquiries that are meant to be constructive and to facilitate a possible accommodation and those that border into harassing conduct. And so we certainly heard about the latter kinds of inquiries when we did our consultation. And the policy gives some examples about ways in which to appropriately inquire into whether there is a disability that requires some support. So we've talked a little bit already about the kind of medical information to be provided. I'll say a little bit more. So clearly, education providers need a certain amount of information to be able to provide an effective accommodation. We also know, particularly in our technological age, that providing this kind of medical information raises privacy concerns for students. And I've talked about the importance of keeping that information confidential, of making sure that it's not shared indiscriminately with people who do not need to have access to it. Give you an example here. Sam, a high school student, is hospitalized unexpectedly due to his disability. Sam's father contacts his teacher to let her know the situation and to tell her that Sam will not be able to submit an essay he has been working on by the due date. Knowing that Sam is in hospital, the teacher does not require confirmation that he has a disability, but asks for information to indicate that his need is temporary in nature and that he will be able to complete his essay once released in a couple weeks' time. Sam's father provides this information and the teacher makes an allowance for the late essay. So this is an example where maybe there isn't a need for medical information. If the relationship is such that there's trust, it's not a protracted request. It's a one-off, very specific request to extend a deadline. Maybe the accommodation doesn't need to be so highly formalized. Of course, there will be cases where the accommodation is more complicated. It expands a greater length of time, where there will need to be this exchange of information. But wherever possible, education providers can accept requests in good faith and just go on about their business. Where more information is needed, it should always be asked for in a respectful way, and the message about the institution's respect for privacy and confidentiality should be communicated to the student and or their family.
On that last example,
Yep.
I was a little confused by the teacher asking for any information that the need is temporary in nature. And maybe I'm confusing that with the disability is temporary.
Yeah, no, the two separate things. So to be clear, disabilities that are temporary in nature have all of the legal protections under the Human Rights Code as permanent disabilities. I'm sorry for that, to confuse that. No, I'm saying that in a discrete situation where there's just a very easy to meet request, which would require a small adjustment, there may not be this need for medical information. It may just be able to be handled between the instructor and, in this case, the parent, and without a lot of formality. So is that clearer now?
Yeah, I guess it's the reference to indicate that his need is temporary in nature as opposed to confirm. Maybe that's what the parent suggested. It sounded like this was a requirement coming from the teacher just because.
No, it's not intended to be that. So we're taking our lead from employment, and in employment, when an employee is absent, an employer is entitled to have a sense of when they might return to work because it has operational impact and consequences. So that's where that's coming from, but I may tweak it now that I've got your feedback, because it's not meant to confuse